warahmatullahi wabarakatuh. Let me introduce myself. My name is Riska Listiyana with NPM 234111142. I'm from Manajemen Class 23B. Here I will explain the material about understanding the law and business law. What is business law? Business law is a branch of law that regulates various aspects of the economic world, such as trade, industry, and business activities. This law is very important because it provides legal certainty to business people, so that they can carry out their activities with legal protection. The scope of business law covers many things, such as contracts, company establishment, consumer protection, taxes, and legal dispute resolution. All these aspects aim to ensure that business practices run fairly and transparently, protect the rights of all parties involved, and encourage an atmosphere conducive to economic development. By understanding business law, businesses can avoid potential legal issues that could disrupt their business. Introduction to the legal system. Role of courts. The judicial system plays an important role in law enforcement and dispute resolution. In this system, courts are divided into several levels with specific authority or jurisdiction, from courts of first instance to high courts. The main function of the courts is to ensure that the law is applied fairly to all parties, as well as to decide disputes based on the applicable rules. With the existing structure, courts are able to provide fair and transparent decisions in accordance with applicable regulations. Key legal concepts. Basic legal concepts, such as due process, precedent, and the adversarial system, where both sides argue in court, are important to understand. These concepts ensure that each party involved in a dispute has a fair chance to defend themselves and that the decision is made objectively by the competent authority. Sources of law. Sources of law consist of various elements, such as statutes, regulations, and common law. Statutes are laws passed by legislative bodies, while common law develops based on court decisions that set precedents for similar cases in the future. Understanding these sources of law helps businesses understand the rules that govern every action they take, as well as how the law applies in society. Key components of a legal contract. Offer and acceptance. Every valid contract must fulfill the basic elements of offer and acceptance. An offer is one party offering an agreement to the other, while an acceptance is the second party's agreement to the offer. This process must be done consciously without any coercion or deception. In addition, a contract also requires consideration, which is something of value exchanged between the two parties, indicating that the transaction is valuable and valid. Offer and acceptance. Every valid contract must fulfill the basic elements of offer and acceptance. An offer is one party offering an agreement to the other, while an acceptance is the second party's agreement to the offer. This process must be done consciously without any coercion or deception. In addition, a contract also requires consideration, which is something of value exchanged between the two parties, indicating that the transaction is valuable and valid. Contract terms and conditions. Every contract must have clear provisions regarding the rights, obligations, and responsibilities of each party. This is to prevent any confusion or disputes in the future, as each party will know exactly what is expected of them in the partnership. A clear and detailed contract will provide legal certainty and reduce potential legal problems in the future. Enforceability of contract. The enforceability or validity of a contract depends on several factors, such as the legality of the object in dispute, the capacity of the parties involved in the contract, and whether the contract complies with applicable laws. If there are elements of irregularity, for example one of the parties does not have sufficient legal capacity or the object of the contract is invalid, then the contract cannot be enforced. Types of business entities and their legal implications. Sole proprietorship company. A sole proprietorship company is the simplest type of business entity and is owned by one person. The owner has full control over business decisions. Partnership. A partnership is a form of business cooperation between two or more people who commit to sharing profits and losses. There are several types of partnerships, such as general partnerships where all partners are fully responsible for the liabilities of the business, or limited partnerships where some partners are only responsible according to their capital contributions. Corporation. A corporation is a legal entity separate from its owners, where the shareholders have rights over the company, but they are not personally liable for the company's obligations. This structure provides limited protection to its owners, so personal risk is limited to the number of shares owned. However, setting up and managing a corporation requires more complicated procedures and higher costs. Limited Liability Company, LLC. A limited liability company, LLC, is an entity that combines the characteristics of both a partnership and a corporation. LLC owners get limited liability protection just like shareholders in a corporation, but have managerial flexibility just like in a partnership. This structure makes the LLC a popular choice for many small and medium-sized businesses because it provides the advantages of both personal asset protection and flexible management. So much material that I can convey. Please apologize if there is a mistake in the pronunciation of words. Thank you for watching until the end. I end. Wassalamualaikum warahmatullahi wabarakatuh.